Dear students, last class we were talking about this anti-dumping module and we talked about the dumping and anti-dumping, what is dumping and what is anti-dumping. And today we are going to discuss about what are the prerequisites, which we already discussed. The first prerequisite, dumping, and the second prerequisite is the determination of injury to the domestic industry, and a causal link between dumping and injury. So, today we are going to discuss the another two prerequisites, that is determination of injury and also the causal relationship along with the definition of industry. So, in this lecture we start with the determination of injury, which is explained under article 3 of the anti-dumping agreement. So, what is this injury is all about? So, the injury is the injury which we talking about to the industry is economic injury. So, we will see what are those parameters of those injury to the domestic industry. So, here the provision very clearly says, in order to impose anti-dumping measures, an authority must determine not only that dumping is occurred, but such dumping causing material injury to the domestic industry producing like product. In the last class we have discussed about what is meant by like product as well, or material injury in this context comprises present material injury or future injury. So, injury to the domestic industry may be the present injury or a future injury or threat of material injury, or in short we can say that the injury must be imminent or material retardation of the establishment of a domestic industry. So, there are so many components in the injury, in inverted commas, the injury factors. So, or what constitutes an injury. So, other than dumping, you have to prove a injury to the domestic industry. That injury can be a material injury present or future injury, that is a threat of injury, or material retardation of the industry. We will dissect these components separately. So, we talked about the current injury, we talked about the future injury, and we talked about the material retardation of the establishment of industry, which is mentioned under article 3 of the anti-dumping agreement. So, article 3 which provides basically the injury factors. So, the details, the volume factor, the price factor and other economic factors of injury. And also you can see that the list of injury factors. What are the list of injury factors to be examined by the investigating authorities during anti-dumping investigations? So, and also the causation analysis, how the investigating authorities are going to analyze the causation analysis. So, the effect and cause analysis, and also how they are going to distinguish between these injury factors and other known factors or other factors. So, if other factors applicable, then the anti-dumping it will not taken into consideration as injury under the anti-dumping agreement. And then if there is any exceptions which are applicable to this particular rule, and also the special rules for the determination of threat of material injury in certain cases. And we will see, we will analyze this separately. And also you can see that in every anti-dumping investigations, the investigating authorities will find dumped imports and non-dumped imports. In case of dumped imports, so certain exporters may be found to be dumping, and maybe from one country or maybe from another country or maybe from another company, they may not be dumping, their dumping margin may be 0 or minus. So, India always argued that this negative injury margin or non-dumped imports should be deleted from the injury analysis. So, it means that once the investigating authorities identify the first factor or evaluate the first factor of dumping, then the non-dumped companies to be or countries to be excluded from the second factor, that is the injury analysis or injury to the domestic industry. So, this argument was put forward by India in the EC India bed linen case. So, the injury, how the injury analysis to be done, the procedure to be done. Definitely in the usual course of trade, the non-dumped import should be excluded, but the practice of countries shows that they do not exclude this. So, that if they do not exclude the non-dumped imports, it will be easy to find injury to the domestic industry. So, this practice of the WTO members are criticized, and that is why the India argued for the non-dumped imports should be excluded from the injury analysis in EC bed linen case. And what are the basic requirements of injury finding? So, injury must be, injury means injury to the domestic industry. The economic injury to the domestic industry must be present, and that must be established on specific criteria. That criteria should be, the basic should be volume or price effects on imports and not other matters, volume effect and price effects. And also the investigating authorities must objectively examine the criteria based on positive evidence. It is not a subjective analysis of the relevant criteria, but objective examination. It means that the investigating authorities must take into consideration of all relevant factors, all circumstances of such kind of dumping, and must be based on positive evidence, not based on mere apprehension or mere conjecture. So, it must be actual injury based on positive evidence to the domestic industry. So, we talked about these injury factors. So, the economic factors, there are 15 injury factors which you can find for the consideration of injury to the domestic industry. So, article 3(4) of the anti-dumping agreement explains these 15 economic factors, which includes actual and potential decline in sales. So, there may be a sudden decrease in sales, due to that there is a sudden decrease in profits, and there is sudden decrease in output, sudden decrease in market share, and sudden decrease in productivity, and sudden decrease on investment, return on investment. So, the entire business is dependent upon the return on investment. Then decreasing utilization capacity, mainly due to due to these economic factors. So, and also this is, you can see the potential decline in the volume, or it is price. So, then we will look into the factors affecting domestic prices. So, the domestic prices, and then also the magnitude of the margin of dumping. So, what are the actual and potential negative effects? And this is the all other, the second category of injury factors are related to price. This includes cash flow, and also this include growth rate, increase in inventories, then abilities to raise capital, employment opportunities, and ability to raise investment. So, the second part is if the first part deals with the volume and second part deals with the price. So, there are 15 economic factors which you can find for the calculation of injury, and which basically all, I would say that it is there is no two categories, the one category, and all are economic factors or financial factors, and other exterior or external factors are not going to be considered for the injury factor, for the consideration of injury factor. So, these 15 factors are very crucial. So, that means the investigation authorities must consider these 15 injury factors when they investigate into the injury to the domestic industry. So, this we will see elaborately in some of the case laws as well, what the panel and appellate body of the dispute settlement body of the WTO also said. In this case, Thailand H-beams case, the panel said that. So, the panel said that. So, this is with regard to the consideration of these 15 economic factors. The panel said that each of the 15 individual factors listed in the mandatory list of factors in article 3(4) must be evaluated by the investigating authorities. So, when an investigation is made by the investigating authorities on anti-dumping, they have to mandatorily consider all these 15 economic factors, 15 economic factors to be taken into consideration for consideration of injury to the domestic industry. So, these factors mentioned in article 3(4) is mandatory after this particular. So, it is clarified by the panel in Thailand H-beams case. So, these economic factors are mandatorily to be considered in each and every investigation. And then you can see that how the material injury is determined. So, material injury is, so we already said that it based on positive evidence and an objective examination of the volume of dumped imports, and it is not only based on the volume of dumped imports, because we said that the dumping per se is not prohibited, but what is their effect on domestic prices, markets, and then consequent impact or its effect on the domestic industry. So, we can see that. So, this the appellate body, that is a dispute settlement body of the WTO, held that this in certain cases it must be based on confidential case file and overruled a panel finding that it follows from the words positive and objective that the injury determination should be based on reasoning or facts disclosed to or discernible by the interested parties. That means, if it is a confidential information, the panel need not disclose what exactly is, but the panel must assess the positive evidence and also an objective assessment of the volume of imports or the positive objective assessment of the evidences produced before it. So, that means that in any cases the members, the countries those who are subject to anti-dumping investigations cannot escape by simply saying that that particular information is confidential in nature. You cannot escape. So, the appellate body made it very clear that, so the panel must do a positive evidence, they must take into consideration of the positive evidence and objective examination of such evidences. So, we already talked about the volume, the volume criteria as well as the price criteria. So, the volume criteria and price criteria must be analyzed. These are the two the economic components. So, the 15 economic criteria will come under these two branches. So, when you consider the volume and prices, especially the volume and price analysis, so the investigating authorities must consider if there is a significant increase in dumped imports. So, whether either absolute or relative production or consumption in the importing member, and also the prices of dumped imports. So, the investigating authorities must consider whether there has been a significant price undercutting by the dumped imports. So, basically we said the definition of the definition of dumping, it is a price comparison. So, the investigating authorities to look into whether there has been a significant price undercutting, and also whether there is any depressing effect on prices or prevent any price increases or otherwise have been occurred in the usual course of trade. So, the volume and prices, the prices to be is very carefully analyzed by the investigating authorities in each investigation when they consider the volume and prices of dumped imports. So, the cumulation principle, which is talked under article 3(3). So, it is what you mean by cumulation. It says that, so definitely the investigating authorities are investigating not dumping from one country. So, they have to consider all the countries those who are exporting that particular material. You cannot pick and choose one country, they have to investigate all the countries. And subject to anti-dumping investigations, their effect may be assessed cumulatively for injury purposes. So, we already said that India argued that these non-dumped imports should be eliminated from the injury criteria, and if the dumping margin is de minimis, that should also be excluded, or the dumping margin is negligible thresholds, within the negligible thresholds. We will see that what is the negligible thresholds under the agreement. Then the cumulative assessment in certain conditions. So, cumulative assessment in certain conditions between imports and the like domestic product. So, you can see that this cumulation should be made. Then many WTO members use this particular methodology. So, and so that the thresholds are not met. So, the cumulation principle. So, the rule that if more than one country is investigated and you have to cumulatively assess the injury matters, or for the purpose of injury purpose should be cumulatively assessed. So, again in Thailand H-beam's case, the panel said that each of the 15 factors are mandatory. This we saw that, and also even the data collected. So, the panel said that it appears from this listing that data was not even collected from for all the factors listed in article 3(4), let alone evaluated by the EC investigating authorities. Surely a factor cannot be evaluated without the collection of relevant data. So, that means every anti-dumping authorities must collect data on all 15 economic factors, to be taken into consideration, and that data 15 economic criteria data should be collected for the calculation of injury in every case. So, this was confirmed by the panel, that is the dispute settlement body, one branch of dispute settlement body of WTO. The panel held that in Thailand H-beam's case. So, it is very clear that all 15 economic factors to be taken into consideration. Then what is the impact of dumped imports? So, the effect of dumped imports to be assessed by the investigating authorities, and also evaluation of all relevant economic factors. All relevant economic factors, we already said that all 15 economic specific factors to be taken into consideration. So, and also article 3(4) says that these 15 economic factors are not exhaustive and it only gives indications. So, these several of the factors can necessarily give decisive guidance. It means that you cannot pick and choose one economic factor, and you have to consider all 15 economic factors at a time for the calculation of injury factors to the domestic industry. So, this domestic industry, what is this domestic industry? So, the definition of domestic industry is given under article 4. This is very important, because you talk about domestic industry, then the question is whether there are foreign industry in your country. So, in a principle you can say that yes, all foreign companies are in your domestic market. The question is whether they are foreign companies or domestic companies. The answer is most of the companies are working in India. For example, their Indian counterpart in the form of partnerships, in the form of collaborations, in the form of subsidiaries, in other legal forms. So, they are not foreign companies and they are considered to be the domestic industries, because they are registered under certain laws of the country. So, the domestic industry, here you can see that domestic industry for the purpose of anti-dumping, and they can be considered in two ways, two meanings. One, domestic producers as a whole, and even it is for the like product, or the producers whose collective output of the domestic product constitutes a major proportion of the domestic production of the like products. So, it means it can be even individual producers of a particular product of the like product, or even collective output of the product constitutes a major proportion. So, it is domestic industry calculation, domestic industry, who is the domestic industry is very important. Only domestic industry can submit a complaint to the respective authorities of WTO members. For we will see that in the next class, we will see that what is the Indian authorities, and the Indian authority is the Directorate General of Anti-Dumping, and if you want to qualify to be an industry, then you have to comply with the qualifications under article 4. So, this is very important for filing a petition, an application before the respective authorities, and also most importantly for injury analysis. These members will be taken into consideration for the data is collected from these particular members for the calculation of domestic industry injury. So, the injury criteria, the data will be collected from this domestic industry only. So, the determination of domestic industry is very important for the purposes of calculation of dumping margin. So, what is this domestic industry? Article 4 of the anti-dumping agreement defines domestic industry. So, it says domestic produces as a whole of the like products, domestic produces as a whole of the like products, or those of them whose collective output of the products constitutes a major proportion of the total domestic production of the product. So, a major proportion is not defined, but the de minimis level is defined, negligible is defined, but what constitutes the major proportion is not defined under the anti-dumping agreement. So, it makes a leeway or a gap for the investigating authorities to determine who constitutes the major proportion. There is a legal vacuum or there is no guidelines. And also in cases there are certain related parties. So, in certain circumstances, so the producers of the like product in the domestic industry or importers and exporters may be related parties. How it happens? In what cases it happens? For example, if Suzuki Motors export engines from Japan to India and to the Indian subsidiary, they are considered to be related parties. So, because why? In the case of related parties, so the investigating authorities look into is there is any price manipulations and also whether they qualify to be domestic industry. So, whether they are related to exporters or importers, related in many ways. So, it can be the same directors, it can be subsidiaries, there can be collaborations. So, it can be related through many ways, and also even the subsidiaries can be the importers of the alleged dumped product as well from the their foreign mother company. So, that also may affect the calculation of not only dumping, the calculation of injury to the domestic industry. So, the related party transactions should be taken into consideration by the investigating authorities. And also you can, in certain cases, they may be considered as deemed to be related parties. So, if there is a relationship between the two companies, this relationship can be in the form of control, this relationship can be in the form of common directors, and this relationship can be a major acquisition as well, merger and acquisition as well. So, if domestic producer and exporter and importer is related through any way, then they will be considered as related parties. Related parties transactions should be taken into consideration by the investigation authorities. Then another important factor is the regional domestic industry. So, the regional, what do you mean by regional domestic industry? So, the special rules will be applicable in that case for the calculation of dumping margin. So, injury to the producers as a regional industry. So, here you can see the separate competitive market is formed by a regional industry, whether they market, sell and almost all of their production of the like product in the same market, and at the same time the demand for the product in that particular market is not to any substantial degree supplied by the producers of the like product located outside that particular market, then that can be considered as a regional industry, and regional industry will be separately considered by the investigating authorities. So, here even in the case of injury exists in that regional case, regional domestic industry, a major proportion of the Indian domestic industry produces outside the region is even the investigating authorities can find injury to the domestic industry, even though the outsiders are not injured in that particular case. So, finding of injury to the regional industry is only allowed if there is a concentration of dumped imports into the market served by the regional industry, and dumped imports are causing injury to the producers of all or almost all of the production within that same market. So, it means there is an exception to the regional industry. So, there is a very strict definition of a regional industry for the calculation of injury to the domestic industry. And also we can see that the affirmative determination of injury to this regional industry can be considered only when the investigating authorities to limit the duties to product concerned for final consumption in the region, in that particular region only. So, if that is possible, then only they will be considered as regional industry. So, we can see that. So, if the constitutional law of a particular, so this is mainly because of which considered with regard to European Union, African Union and other kind of regional organizations, regional industries from different countries. And if the investigating authorities levy duties on all imports of that particular product without limitation, then the anti-dumping duties cannot be limited to the imports from specific producers supplying that particular region. It means that, so the investigating authorities to be careful when they impose anti-dumping duties from regional industries. So, and also they were the authorities, the investigating authorities must offer exporters an opportunity to cease dumping in the region or enter a price undertaking. So, it means that in the case of regional industries, there are certain concessions. So, these concessions include the authorities must offer exporters an opportunity to cease dumping in the region or enter a price undertakings. So, this is to be taken into consideration. And also you can see that rules for cumulative assessment. We talked about the cumulative assessment. So, there are rules for cumulative assessment as well, because in most of the investigations there will be more than one exporters or one importers or more than one country. In that case, how the anti-dumping investigation is done, how the cumulative assessment is to be made. So, in case of imports from each country, from individual countries, and it will be considered as de minimis if it is less than 2%, if it is not less than 2%. From volume of imports from each country, volume of imports from each country is not negligible, that means not less than 3% of the total volume of imports of a like product, unless that particular imports are individually accounted for less than 3%, collectively and individually account for 3% and collectively account for 7% of such imports. That means, the how this particular provision which talks about how the cumulative assessment can be made. So, the cumulative assessment is appropriate in the light of the conditions of competition between imported products and the like domestic product. So, article 3.3 which talks about the rules for cumulative assessment, and then comes the third prerequisites for imposing anti-dumping duties. So, the third criteria is the causal relationship, the causal relationship between dumping and the injury to the domestic industry. So, this is the third criteria or prerequisite for imposing anti-dumping duties on any products which is came to your market. So, we will see that what is these causal factors. So, injury factors, we saw that there are 15 injury factors, and what are the causal factors? So, here you can see that. So, the causal factors, again here also it is import volumes and price volumes, or price differences and import volumes. And here also the domestic industry has whether suffered a material injury. So, indicative of whether the injury has been caused by these particular dumps. So, it means that there must be a cause and effect on the dumping and injury, otherwise it cannot be attributable to other factors. So, it is very clear that dumping must be related to the injury, the injury must be because of the dumping, and if this causation factor, the cause and effect factor, if cannot be approved, then there will not be imposing anti-dumping duties. So, the causality factor is very important to be examined, and also the other factors. For example, the other factors which includes volume and price of imported goods, the contraction in demand. So, the introduction of new technologies and restrictive trade practices. For restrictive trade practices includes these the anti-competitive practices, abuse of dominant position. So, the activities, for example, cartel, tie-in arrangements. So, these are the activities which against the market principles or against the competition law. Development of new technology. So, if your product is not selling in the market because your product carries an old technology and a new technology comes to the market, the old product, the stock of the old product increases, then you cannot blame it for the new manufacturer. For example, in the case of the smartphones. So, the earlier phones were disappeared when the smartphones came to the market. So, you cannot file an anti-dumping case against the smartphone suppliers for the increase in volume, increase in the stock of the old telephones. And then productivity, definitely the productivity depends upon the product and also the market demand or market contraction. And then it shall not be attributable to the injuries caused by other factors. So, that means these other factors, this attribution provision is very important. These other factors cannot be attributable to injury determination. So, the causality factor is very clear and the other factors are also very clear, and these other factors cannot be taken into consideration. Other factors cannot be taken into consideration for the calculation of injury to the domestic industry. Again in the Thailand H beams, the panel has the taken into consideration of these factors, non factors. So, the non factors other than the dumped imports. So, what the panel said? The panel said that injuring the domestic industry, but does not make any clear how factors are known or are to become known to the investigating authorities. So, we consider that other known factors would include those causal factors that are clearly raised before the investigating authorities by the interested parties in the course of anti-dumping investigation. So, we are of the view that there is no express requirement under Article 3(5) that investigating authorities seek out and examine in such case on their own initiative the effect of all possible factors other than imports that may be causing injury to the domestic industry under investigation, I unquote. So, in Thailand H beams, the panel basically said that the other factors should not be taken into consideration for the calculation of injury. And one more case which we can see is the Mexico corn syrup case. Mexico corn syrup case also the panel said that, so the factors to be taken into consideration for the threat of injury. So, we said the injury must be present or injury must be future, there is a threat of injury. In that case alone is that means that analysis, threat of injury analysis is alone is not a sufficient basis for a determination of threat of injury, because the Article 3(7) factors do not relate to the consideration of the impact of the dumped imports on the domestic industry. So, what is the view of the panel? In our view, consideration of Article 3(4) factors, 3(4) factors, remember the 15 economic factors, in examining the consequent impact of imports is required in a case involving threat of injury in order to make a determination consistent with the requirement of Article 3(1) and 3(7). So, the panel in Mexico corn syrup also said that when you calculate, when you take into account of the threat of injury, these economic factors to be taken into again consideration is there is any threat. So, these economic factors are crucial for the calculation of injury to the domestic industry and even causation factor. We said that threat of injury. So, what the agreement says? So, that means the threat of injury means it is only a threat, not in the present. In the future, it may be there is a material injury which will develop if the anti-dumping duties are not imposed. So, it is a future event. So, how the future event? It is very difficult to calculate, it is difficult to find out the future, what is going to happen in the future. So, it means that the dumping, the industry is going to be injured is very imminent. So, you have to produce sufficient evidence to prove that this dumping is imminent, and not only dumping, material injury to the domestic industry also imminent. So, the future injury that is imminent. So, this must be based on positive evidence, not allegation, not conjecture or not mere possibility. So, it can be decided, it should be very clearly, the threat of injury should be taken care by the investigating authorities very carefully, the threat of injury to be taken care by very carefully. And also the authorities must consider other factors. And what is this other factors? Significant rate of increase of dumped imports, significant increase in the dumped imports, which shows a likelihood of substantially increased importation in future as well. Then sufficiently freely disposable or an imminent substantial increase in capacity of the exporter. Third criteria, whether imports are entering at prices that will have a significant depressing and suppressing effect on domestic market. Not only on the market, domestic prices, and that will increase the demand for further imports. So, and also the inventories of the exporter and importer is also very critical factors into taken for the determination of threat of injury in the future. So, we can conclude this threat of injury factors. What are the threat of injury factors? This threat of injury factors are a significant increase of dumped imports, 1. 2. Freely disposable or imminent substantial increase in capacity of the exporter, or likelihood of substantially increased dumped exports to the importing members market. Then whether imports are entering into the prices, the price criteria at a very lower level, significant depressing and suppressing effect on domestic prices, and also which will lead to the high demand of that particular imports. Then inventories of the product also to be investigated. So, these are the threat of injury factors to be taken into consideration by the investigating authorities when they investigate on the future threat. So, threat of injury factors. So, here the main problem is in the decisive factor, the threat of injury, how to be calculated. There is no guidelines as such. So, how the totality of these factors to be taken into consideration, there is no guideline which is provided. This is the panel said in Mexico corn syrup case. So, then we saw that the last criteria, injury to the domestic industry, future injury or threat of injury to the domestic industry, and the last criteria is material retardation. Actually, here also the WTO agreement does not give a guideline with regard to how the material retardation is to be calculated. So, it is up to the investigating authorities to determine how this gives a lot of leeway or lot of gap or lot of freedom to the investigating authorities to determine the material retardation. What do you exactly mean by? So, I would say that it must be based on this economic criteria rather than any other criteria. Then comes the imposition of duties. So, it is very important to note that the anti-dumping agreement says that imposition of duty is not mandatory. And the second criteria, the anti-dumping duty should not exceed the margin of dumping. And third, again it says that it is known as the lesser duty principle. If the members, it is desirable that if the duty be less than the margin of dumping, the duty is imposed less than the margin of dumping, the lesser duty would be adequate. So, the first the members should see that what is the dumping margin, dumping to be imposed, anti-dumping duty to be imposed, what is the appropriate percentage of dumping duty. It is not equal to as that of, it is not necessary to be equal to as that of the dumping margin. If a lesser duty is sufficient, that lesser duty to be imposed as anti-dumping duty. And also each member should take care of and look into the public interest. Every government, before imposing anti-dumping duties, to consider the public interest as well for imposing anti-dumping duties. So, in conclusion, I would say that injury to the second criteria of anti-dumping, imposition of anti-dumping duties is injury to the domestic industry. Not only injury is in three forms: injury, the present injury, the future injury, threat of material injury, and material retardation of the domestic industry. But there are a lot of freedom to the investigating authorities is given for the calculation of domestic industry. Cumulation principles, the cumulation is also give lot of freedom, and who is a foreign industry and who is a domestic industry, this is also a question, and also related parties are also always a question. and the injury factors. Most of the investigating authorities doesn't look into the all total 15 injury factors, even though the panel said that it is mandatory to look into all these 15 injury factors. So, material injury factors are not very clearly defined. So, I would say that, so without material injury, material injury and material retardation of the domestic industry, no investigating authorities should impose anti-dumping, recommend for imposing anti-dumping duties. So, in this lecture we covered basically the injury criteria, and also we covered what exactly mean by the domestic industry and how the duties can be imposed, to what extent the duties can be imposed. And in the next lecture, we will see the procedural aspect of anti-dumping duties. Thank you.